Good morning. My name is James Kim, Chairman and CEO of AMCHAM Korea. Thank you so much for joining us at the Human Resources Committee webinar. We want to thank you for participating in our HR virtual seminar series. As we all know, COVID has changed HR and the labor policies in Korea and around the globe. Today, we're going to discuss a topic that is so critical for all of us, and we call it understanding and navigating through critical labor and employment law issues affecting your business in 2021. I must admit, we have a very knowledgeable panel of experts joining us today to talk about these recent challenges, such as increased union rights, the impact of workplace harassment claims, and the 52-hour work week. We have three speakers from Kim and Chang with us today. And every one of them are really fantastic experts and very knowledgeable. First, we have Matthew Jones, Hyun Park, and Robert Flemmer, all amazing experts in this topic. Before we begin, I want to thank our HR committee co-chairs, Yumi Jun from Kelly Services and Mira Lee from GE, for their amazing contributions, which obviously helps all of us. We're also going to have another HR committee webinar in the next few weeks, and we're going to talk about trends in the labor market. So please stay tuned. So without further ado, let me hand it over to Matthew Jones. He's also a co-chair for the HR committee, and he continues to make amazing contributions to AMCHAM and to this HR committee. So Matthew, the floor is yours. Thank you.
Thank you, Jim. It's great to be here. And let me just reiterate on behalf of Yumi Jun and Mira Lee, we thank you all for taking the time to get updated on some of the critical labor and employment laws that are affecting your business this coming year. As far as labor and employment law goes in Korea, it's safe to say that the last 5 years have been extremely dynamic. One of my senior colleagues at our firm here recently commented to me that there's been more changes to the Korean labor and employment laws in the last 5 years than in the previous 25 years before that. So there's a lot of things to keep abreast of. And if we look at all of the changes, we can see a general trend towards providing more benefits and more protections for employees. So it's very interesting that within that context, we have a recent Supreme Court case that in some ways goes against that trend a little bit. And so we'll be talking about that. And that court case deals with dismissal for poor performance, which I know is an issue that every company deals with, and it's one of the most common questions that we receive here at our firm at Kim and Chang. Another recent development is that the Korean government has recently ratified certain ILO conventions, the International Labor Organization conventions, which is going to have an impact on the laws related to labor unions and managing labor unions, which we know affect a lot of you out there as well. So we have some very important and good topics to go through today. I just want to briefly introduce my colleagues a little bit more. So we have Rob Flemmer. Rob Flemmer is a senior foreign attorney here in our labor and employment practice group. Rob actually started his career right out of law school working in labor and employment in the US for over 10 years. And he has been now in Korea for many years and has really become a vital member of our team advising our foreign clients here. And then we also have Hyun Park, senior Korean attorney, very sort of important member of our firm that I would say has seen it all and done it all as far as Korean labor and employment issues. So I'm very happy to have them both join us today. And we want to make this presentation very interactive. So between the three of us, we'll be asking each other questions throughout the presentation, but we also welcome you to post any questions you have in the Q&A box. We'll keep an eye out for that, and we'll try to interject with your questions as well. And we'll, in any case, get you out of here by 10:30. So with that, I'm going to turn it over to Rob to get into the first topic of developments in the managing of poor performance based on this recent Supreme Court case.
So thank you, Matt. So before I get into the Supreme Court case that you had mentioned, I want to talk about some of the challenges that companies face related to performance management in Korea. And especially in the context these days of COVID-19 and the issues related to working from home. So many employees are working from home. Performance management has become increasingly difficult, I would say, or at least challenging. And it can also be challenging on the basis concerning different perceptions of the validity of performance management. There might be cultural differences. There might be differences between labor and management about whether or not you can even manage people's performance and discipline them for that. And then matching your global policies or your regional policies or your policies from your home office to Korean legal and practical requirements can be challenging as well. And of course, there is the strict just cause standard to discipline employees for poor performance, which is a very high bar. And one of the other issues to think about in the context of this case, because it dealt with ordinary dismissal, is ordinary dismissal versus disciplinary dismissal. And you may all recall that there was a guideline that was issued by the Ministry of Employment and Labor under the previous government that provided a process, a step-by-step process for performance-based ordinary dismissals. And the current government has abolished that. So that kind of left things unclear as to whether or not that was still an option or not. And especially since ordinary dismissal as a concept was rarely accepted as a basis for dismissing people for poor performance. It was alluded to or referenced in some cases, but never directly addressed like it was in this case.
So Rob, if I can just stop you there for a second.
Sure.
For our listeners that may not be familiar with this concept of ordinary dismissal, which is not something that we hear about, in the US, for example, could you just briefly explain what is ordinary dismissal versus what's another type of dismissal that's out there?
Mm-hmm. So ordinary dismissal occurs when, or the concept is based on an employee lacking the capacity to do their job, to do the position. Like they just can't do it. And you have to, it's the same level of proof that you would have for a just cause dismissal. It's a similar thing. So examples of that would be, for example, the worst case, someone passes away. They can't do the job anymore. Or another way is if they reach the statutory retirement age. That's another basis for ordinary dismissal. So in the context of poor performance, you have to establish that they just don't have the capacity to do the job, and then you can dismiss them through this ordinary dismissal process.
Okay, great. So yeah, maybe we can get now into that Supreme Court case.
Okay. So this case, which involved a very large conglomerate, it has over thousands of employees, was decided by the Supreme Court on February 25th of 2021. And it involved two longtime manager level employees with over a decade of experience each. One was in production, one was in quality control for this company. And the company had a policy where the lowest 2% of scores on performance reviews, the employees, as averaged over a 3-year period, they would go into the PIP process. So in this case, they had these two managers along with 63 other employees, so a total of 65 employees were put into this PIP. And 24 employees, including the plaintiffs, the two plaintiffs, didn't pass that PIP process.
Okay.
So about that PIP process, this was very involved. So this was a 10-month PIP process where each of these employees was actually removed from their regular work duties and put into a training program. So for almost a year, they were working on training these employees through this PIP process. So they didn't have to do their regular duties. They were completely focused on performance improvement. And so after that process, these two employees in particular did not pass the PIP, even though after 10 months. And so they were reassigned to new positions that were similar to their old ones, but were new, so that they would be given another chance to perform in a different position. And in these new positions, they actually made some mistakes that had monetary consequences for their employer. Employer lost money essentially because of what they did. And after 4 months in these new positions, the employees were evaluated and have failed the evaluations because of these mistakes. And following that, they were given 30 days notice and dismissed through ordinary dismissal. So you're looking at a process of over a year, 10 months plus 4 months, plus another month for the ordinary dismissal notice. It's almost a year and a half.
Interesting. So if I can just stop you there, and we'll be going through, the key takeaways, but before this case, if a client came to you and said, we've had an employee on a PIP for 10 months, where all he did was training. We reassigned him. He made mistakes, so he failed that after 4 months. So in total, we've had 14 months of this employee being under our kind of close evaluation, and he failed. Can we terminate him? What would have been, your advice?
Yeah, so I mean, we have in the past recommended that performance improvement processes be 9 to 12 months. So that duration of time is within that range. So we would certainly note that. But in the past, we've often argued that or recommended that the person go through a disciplinary process. So it was unclear if ordinary dismissal in the past would have been another option because that guideline had been removed. Now we have a definitive response to that issue with the Supreme Court case. So that sets kind of an outside limit, I would say, or a boundary where you really have to do a lot. I mean, the company did a lot in this case and expended a significant amount of resources on this to get this done. So it's possible. In the past, I would have said it would be more difficult, but now it's a little bit less difficult. It's still a lot of work, though.
Right. Actually, there was some actual argument by many of the plaintiffs' attorneys that ordinary dismissal is not permissible under the Korean labor law. And when I had some cases before, not the judges, but the labor commissioner in the Labor Relations Commission, some of the commissioner even mentioned that they are also not sure that whether ordinary dismissal is permissible. So they recommended disciplinary dismissal rather than ordinary dismissal. So
right.
Now we can quote the Supreme Court Supreme Court cases.
It gives you another option. There are 2 tracks now instead of just 1.5, because ordinary dismissal was always out there. There wasn't a clear response from the authorities or the courts about whether or not it was valid.
And I think this is a very interesting point, because from a legal perspective, when we're advising our clients that are dealing with poor performers and may have to look at possible termination, we say, well, from a legal perspective, it's better to take this progressive disciplinary action process because the previous guidelines that allowed for ordinary dismissal had been abolished by the current presidential administration.
That's right.
And so what does that mean practically? You have a poor performer who you want to rehabilitate, but then after 3 months, you reduce his salary for a period of time, or suspend him without pay for a period of time. This is what we have to recommend in order to build up our case for just cause for termination. But from a practical HR management perspective, this does not give encouragement or a morale boost to employees that you're trying to help improve. In fact, in some ways, it's degrading. And so that's kind of the dilemma that we face even today when we're trying to advise companies that are dealing with poor performers. So ordinary dismissal is in some ways a more fitting type of way to dismiss an employee. And so this Supreme Court case, I think, does in some ways revive or open up the door for that route rather than the disciplinary action process. But I think it does also come with some downside as well, which is, at least with disciplinary action, you are taking a progressive step-by-step approach, increasing it step-by-step. And so you're building up the grounds, whereas if you're taking the ordinary dismissal approach, you're basically just doing PIP and reviews and things like this for a period of time, and then suddenly just termination. So there is a little bit maybe of a risk that employers will take in that sense, but in some ways from an HR management perspective, it may be a more fitting approach.
Yeah, and certainly with an ordinary dismissal approach, you could at each failure of the PIP, you could have some kind of written warning or something, or notice that, you know, they could face some kind of disciplinary action at some point. But yeah, I mean, if you're using the progressive disciplinary policy, I think it's going to be an easier, I would say, relatively speaking, argument that you have done everything that you can short of termination. If you've done all the disciplinary steps and the person still hasn't improved their performance, that gives you the next logical step of, okay, I have no choice now but to terminate because they're just not fixing their performance. So in that respect, disciplinary dismissal, I think, has a better basis potentially. But from a practical perspective, it may be better to take the ordinary dismissal route, because in that route, you're actually undertaking what the whole point of a PIP process is to improve performance. You're waiting to the very last to actually resort to termination.
Okay. So we're now going to just get into some of the challenges and takeaways about this case. But before we do that, again, I just want to encourage anyone that has any questions to go ahead and submit those questions. We are on the lookout for them, and we'll try to answer them as we go through.
So, and we've touched on this already in terms of the performance evaluations. So performance evaluations by multinational companies tend to be very subjective in our experience, based on comments from managers who are often in the region. Actually, they're not even in Korea sometimes. So this can make sense from an HR perspective, especially in professional type positions where a lot of what you do is kind of subjective, how people interact with each other and how they interact with customers and clients and things like that. And so you don't have those real, dollars and cents measurements or grading scales that you might be able to use with, say, like a sales employee. But the courts and the labor authorities still expect to see those measurable KPIs. And so we recommend that to the extent that you can, to establish those measurable KPIs or use those measurable KPIs that are favored by the fact finders.
Right. So what you're saying is, while many companies, in fact, will provide some like long narrative to provide feedback,
yeah,
and that's, I guess, fine. As it comes to potential review by a court or labor authority, it is helpful if you have some type of numbering or lettering
that's
system to show how they are ranking and stacking up in the overall analysis.
Right. The narrative can still be very helpful from giving people, employees, appropriate feedback. So you don't want to necessarily abandon that. But if you can integrate in some measurable KPIs, that's going to improve your system from a legal perspective.
Right. And also common pitfall of making subjective comment is because managers, sometimes their expression is not clear enough to define someone as a poor performer in the eyes of a litigator. So we have seen some cases, company put someone in the PIP, but the grounds for such PIP decision based on the subjective comment. And when we read the manager's comment, it wasn't that bad enough. So the court really focused on manager's expression and found that that PIP is not legally sustainable.
We do have our first question. So thank you for the person who submitted this. So the question is there a difference in the standard of review in ordinary versus disciplinary action dismissal situations?
I would say no, though it's all based on the same clause of the LSA Article 33 requiring the just cause. And so basically the standard is the same, but in this Supreme Court says it reiterated that relative poor performance is not enough for ordinary dismissal, and it should be clearly substantiated that this employee really cannot perform the given job. So I would say the standard for ordinary dismissal is still quite high despite of the Supreme Court decision.
Yes.
Okay. Let's go to the next page.
So we already touched on the progressive disciplinary policies and actions being still a valid alternative. And as Hyun just mentioned, significant poor performance, according to the Supreme Court, is what is required. That relatively low performance is not enough. You really have to demonstrate that there was significantly poor performance. So some of the things, and we've touched on this as well, having objective criteria to select employees for PIP. So you should have criteria that are applicable to all employees, because in our experience, oftentimes putting someone to a PIP will be more reactive and subjective someone's just not performing that well, and so you'll set up a PIP for them. Whereas you should have an evaluation system, ideally, that applies to everyone that you're looking at on a fairly regular basis. And your performance evaluation system, having multiple evaluators is a good idea, and giving employees a right to give feedback or appeal, like kind of a 360 approach, looking at it at their evaluator as well, is something that you should consider. And the PIP itself should have sufficient training opportunities and give employees a chance to return to work. Because as I mentioned, the whole point of this process, in theory, is to get an employee back to work and to improve their performance. And so that really should be the bedrock for these systems and why you're doing it in the first place. And then having a documented PIP policy. A lot of times there won't be a PIP policy. You'll create a PIP for each employee and set standards and guidelines and things on a rotational basis as you're rolling the PIPs out. So having a PIP policy that has these criteria, the evaluation system itself, and then that is noticed to employees and is available to them so they've seen it, is recommended.
If I can just jump in with one story here. This was a few years ago. I had a client that was dealing with some very poor performers. Basically, the employees were just kind of sitting around doing nothing for many, many years. And he wanted to put them, he wanted to separate them, of course. And he decided to try to use this PIP. And so what we helped him do was create a PIP system. And as part of the system, there were 3 stages. And each stage in that particular case, if you passed, then you're out. If you fail, then there was some disciplinary action. But the map showed that if you get to the very end and you failed each time, it does result in dismissal. And what he was able to do was to show this map to the employees and say, this is what's going to happen. And they could see, oh, it's going to result in dismissal. I remember he used the word, this was gold for him, because it gave the employees a clear sense of what's going to happen, down the route. And based on that, they were able to, at a very early stage, before even going into the PIP, enter into a mutual separation agreement. And if, as you know, for those of you that have been in Korea for a while, when you are dealing with poor performers, or really for any reason that you need to separate employees, the most common way to do that, that is also, I think, the most risk minimized, is through a mutual separation agreement. And so, this PIP process, having a robust PIP system, will also help you, in reaching a mutual separation agreement with employees. Okay, next.
So I think we actually got another question on the performance issue.
Right.
So how should we manage if an employee said he or she is facing a mental health issue, depression and anxiety, during the PIP process? Should we stop the PIP process? I'm gonna give a lawyerly answer and say maybe. A lot of this is case by case evaluation. So I've certainly had even recent experience where an employee raises, for example, a harassment claim. They're saying they're being harassed by the person who's imposing the PIP. So in that case, or in the case of someone facing some kind of mental health issue, you need to look at that claim or issue that's facing the employee, and if it's appropriate to, for example, put them on a leave of absence for medical reasons, or to do a harassment investigation, which you often want to do because the law requires you to do it, you can pause the PIP and then pick it back up again if that's appropriate. So we shouldn't proceed full speed ahead with the PIP. We should pause for a second, take a look, and then if there's not an issue, go ahead. If there is an issue, address that issue, and the PIP can always be picked up again later.
Right, and also I think that the employee, if they're also being advised by a lawyer, they will raise this workplace harassment issue, which meaning that this PIP itself actually designed to harass that employee. So if the employee makes this workplace harassment issue, as you all know, employers has obligation to look into the case and also take an interim measure to protect the employees.
That's right.
So to be on a safer side, as Rob said, we recommend temporarily stop the process and do the internal investigation based on its workplace harassment policy as quick as possible and make a decision, and then resume the PIP again if necessary. And one other thing I'd like to note is the employment subcommittee of the Congress, they just passed a new law that to impose some administrative fine to the employer's workplace harassment.
Right, and I believe that fine is going to be 10 million won.
Yes, that's correct. So there's a good possibility that in the later, employees may argue that implementation of the PIP is actually employer's workplace harassment, and they may file a claim before the Ministry of Employment and Labor.
We have another question. So thank you for the questions coming in. The question reads, I have less than 50 headcount in Korea. Is this type of ordinary dismissal a practical option, considering that there is less room for such PIP process? How much effort in practice is this requiring taking in the court case?
Yeah, this hits one of the main issues right on the head, because as you can see in the Supreme Court case, this company invested a lot of resources and time into this PIP and performance process. It may not be practical for a smaller company. And so, I mean, ideally you would go through all these different steps and spend this amount of time on this. But I'd say the more you can do, the better, because that increases your chances of being able to go through the ordinary dismissal process. But if you want to go down this route, it is going to take a lot of resources. It's that just to be upfront about it. So it may not be practical for you, but if you want to have a performance evaluation and a PIP program, for a PIP, you definitely need a policy in place, and you need a process for selecting employees to put into PIP and evaluating them and giving them enough opportunities. So it takes a lot of time for especially your HR professionals to do that.
Right, and I would just add, I mean, regardless of the size of your company, adopting a PIP policy is not too hard, and adopting the process. Obviously, you may not have the resources to put someone into only being trained, so they'll have to continue to work. And you may not have 10 evaluators. You may only have, 2 evaluators, for example. But I think there are ways to scale your PIP to fit, the size of your company and how much resources you are able to, devote towards it. So I think this is still applicable to any size company. Okay, so thank you for those questions. We're going to move on to another topic in the interest of time. This involves the concept of employee representative. Now, you may have heard this topic of employee representative. It does come up from time to time. And for those of you that have employees of 30 or more, you may be aware that there's a requirement to have a labor management council. And when we tell companies, oh, to do this, you need to have an agreement with the employee representative, some people say, oh, we have that. We have the labor management council. So we wanted to clarify off the bat that there is a difference between the employee representative versus the labor management council. In fact, these are 2 different concepts under 2 different laws. The employee representative is under the Labor Standards Act, and the Labor Management Council is under a separate law, the Labor Management Council Act. So what is the Labor Management Council? I'm sorry, what is the employee representative? It is defined down here. If you have a labor union that represents a majority of your employees, then it's the labor union leader. In case of no majority union, then it's an employee that was elected by a majority of the employees. And the law does not currently specify any details on how the employee representative should be elected by a majority of the employees. It's really just up to them to run their own process. And so the role of the employee representative is that this person has the authority to consult, or in some cases agree with the company on certain managerial issues, such as layoffs and alternative work arrangements, to just give a high-level example. The Labor Management Council, on the other hand, is modeled after the European Works Council system. As I mentioned, it's a legal requirement for any company with 30 or more employees. There have to be equal representatives on the management employee side. They must meet every quarter, and it's primarily a consultative body. There are one or two, there's a very short list of things that we need agreement with the LMC for, but most of the times it's just reporting or consulting with them about issues that impact employees and the company. And so it's really just meant as a way to facilitate communication between the management and employees. It's not a bargaining body like a labor union. One point to note here is that under the current law, the employee side representatives of the Labor Management Council do have to be elected through a direct, secret, and anonymous voting process. So the development here is that, as you know, there is this tripartite commission in the government comprised of representatives from the government, labor, and private sector. And they reached a tripartite agreement in October of 2020, agreeing that the employee representative, number one, if it's a majority union, then it's the union leader. But if the LMC members were elected through a direct, secret, and anonymous ballot, then the employee members of the LMC shall serve as the employee representative. So now, again, this LMC members have two functions, both LMC and employee representative. The term of an employee representative would be up to 3 years. Previously, there was no term for the employee representative, and the employee representative can request for information or documents to the employer, which again is a new right that previously did not exist. As I mentioned, this is just an agreement at the tripartite commission. It is not law yet, and that's why this particular subheading of this topic has a question mark at the end. At this point, there's no indication of when this will become law, but once passed, the LMC will become more powerful, obviously, because they will have the authority of the Labor Management Council.
Right, and because this subject was not really heavily contested between the union side and the employers association, we believe that there's a high chance that this will become a law in a near future.
Yeah, and conceptually, it basically harmonizes the majority union approach with the elected employee representative approach, because the majority union, they automatically become the employee representative and the LMC representatives. So this is basically, if this passes, taking that concept and applying it to the elected employee representatives of the LMC and the employee rep as well.
Good point. So as I mentioned at the beginning, the employee representative is the counterparty for various management-related issues, which we've listed out here. So layoff consultation. If you want to even start a layoff consultation, you have to appoint this employee representative. If you want to implement any agreement regarding flexible or alternative working hours, such as a selective working hour system, you need to have an agreement with the employee representative. If you want to introduce compensatory leave, which is rather than compensate for overtime or nighttime or holiday work in the form of cash, you can compensate in the form of extra leave. This requires agreement with the employee representative. If you want to have an agreement to designate certain days of the week or parts of the year as annual leave for the entire company, then that requires agreement with the employee representative. These have been around in the law. The new one is that an agreement to allow the employer to substitute holidays now requires agreement with the employee representative. So what does this mean? Under the previous law or system, let's say you have an employee and you want that person to work on Christmas Day. It's a holiday. So normally that's a day off at your company, but by just giving 24 hours notice, you can say, employee A, please work on Christmas and then take the following day off. So that was within the employer's right to do at the employer's discretion. It gave you flexibility. It was easy. But now with this new law, we need to have an agreement with the employer representative. You'll see that this amendment takes effect from January January 1st, 2021, for companies with between 30 and 299 employees. It's already taken effect for companies with 300 or more employees. And in that regard, there was actually a recent case that we'll just briefly tell you about. This involved the giant eMart in the retail industry. eMart, as you know, has, I think, over 150 stores throughout the country. And what they did was the employees, or the company arranged for each store to appoint one representative of the employees. And then that resulted in having 150 representatives from each of the stores. And then that group of 150 then appointed another representative. And there was some agreement made with the company about working on holidays and substituting holidays. And the employees filed a claim last year saying that this type of indirect representation is not valid, and therefore, the employee that the agreement was made with is not, a valid employee representative. So this case is currently pending. We don't have a decision yet, but it does show that if you are going to go through the process of appointing an employee representative, it's safer to do it properly. And one final point I'll make about this, which I think is a good one. I've had several clients come to me and say, okay, we want to implement, for example, compensatory leave. And I'll say, okay, you can do that, but it requires an agreement with the employee representative. And when I tell our clients that, they get a little nervous, like, oh, I have to tell the employees to appoint their representative. They feel a little uncomfortable because it feels like they're sort of getting organized and having a representative. And so some companies are a little bit hesitant to do that. But if you have a labor management council, which again is a legal requirement for any company with 30 or more employees, it is possible even now to have your labor management council employee representatives serve as the employee representative if at the time of election, you specify that these people are being elected not only to serve as your LMC employee representatives, but also your labor representatives under the Labor Standards Act. And so by doing that and just adding that wording into the election documents, you can have your LMC members as your employee representative even now, and that may be kind of a smoother process to have the employee representative elected, and I think give less of a sense that you're somehow encouraging the employees to organize or something like that. So I just wanted to share that as a practical tip. Okay, so let's move right along to key takeaways from this section. Again, with the introduction of work from home after the COVID-19, a lot of people are not in the office, so it's difficult to track their work hours. There are a number of flexible working hour arrangements under the law that do require agreement with the employee representative. So this may be a good opportunity to look at appointing that employee representative so you can implement some of these flexible work arrangements. You may want to review your election process for the employee representative and even consider if it's possible to have your LMC members appointed as the employee representative either right away or at the next election. And as we said, once that tripartite agreement becomes law, the LMC members will have more authority, and which would mean that the LMC as a whole and your relationship with your counterparts in the LMC will be that much more important. So therefore, building trust, building up that relationship with your LMC members, is always a good idea. Okay, we have about 20 minutes. Do we have any questions? Nope. Okay.
Not yet.
All right. So again, we welcome any questions you have, but in the meantime, with the remaining 20 minutes, we're going to go into the next section of expanding rights of labor unions. And for that, I'll turn it over to Hyun.
Right, so thank you, Matt. So in this section, I'll briefly talk about the recent developments in terms of a labor management relationship, including the ILO convention and the Union Act that will be effective from this July. So first of all, I think most of our audience are already aware of the fact that recently the unionization rate has been increased dramatically. So based on the recent statistics from the MOEL, the current unionization rate is increased up to 12.5%. And the one notable thing is for the big companies with 300 or more employees, the unionization rate is over 50%. So we can assume that most of the big companies, they already have the union. And as we all know, KCTU now has been the #1 labor union, surpassing the FKTU. And there's a lot of still competition going on between these two big labor union to recruit more membership. So as for the recent update, I want to briefly highlight 3 things. So in this January, the Labor Union Act, it passed the parliament, so it will be effective from July 2021. That generally expands the scope and rights of the union, which we will discuss briefly later. And second thing is the parliament also ratified the ILO Convention number 87 and 98. And the government will submit the ratification to the ILO as early as this March. And the ILO will be effective after 1 year, meaning March 2022. And that means it has the same effect as the Labor Union Act of Korea. So that will raise some issues that we'll also discuss later in this presentation, because there are some still difference between the ILO Convention and the current Labor Union Act. And lastly, I also want to highlight that MOEL, starting from last year, really started to accept the establishment of special task workers union, including the delivery drivers and insurance agencies. And actually, it's the insurance agencies union. They filed the submission more than a year and a half ago, but MOEL has been reviewing. But because the Supreme Court is now really making decision that all these type of special type workers can now unionize from 2018. So the MOEL position has been really changed, and I believe they're almost like accepting every application for unionization from this special type workers. So under the new Labor Union Act, I believe most of our audience already got our newsletter, so they are all aware of the key changes. So I just highlight a few updates. So first of all, financial support to the labor union is permitted. This has been permitted from June 2020 based on the Constitutional Court's decision. And under the new law, so dismissed employees now can maintain the union membership. So previously, they were only allowed to maintain the membership until the decision by the National Labor Relations Commission was made. But because of this new law, so dismissed employees can maintain the union membership for indefinite period of time.
So if I can just step back there. So financial support to the union is permitted. This is a big change, right? Because several years ago, the law was introduced that financial support is prohibited, but there's going to be this paid time off system for a certain number of union officers can be paid by the company, but there was a cap. Does the paid time off system, is that still effective? Or how does that work with this change in the law?
So the pay time off system is still remains the same, but this law is talking about companies' direct financial support to the labor union itself, not in a form of salary provided to the union officers. So in the past, as you have mentioned, the government was taking very serious position that companies should not provide any financial support to the labor union, especially supported by those series of Supreme Court decision that was made in 2016. But now, since the Constitutional Court said that that law does not comply to the Constitution, so current law provides such financial support to the extent that it does not compromise the autonomous operation of the labor union. And the presidential decree of the Union Act, they give us some detailed criteria of to what extent can the company provide the financial support. But if you read the law, it's still very broad and vague. So it will be also very decided on a case by cases. But we are actually expecting and actually seeing a lot of demands by the labor union to start providing certain financial support For example, the fees for their rent fees for the union office and their bills for electronic city. So that we are seeing that kind of request during the recent CBA negotiation these days.
So I think it's interesting to briefly mention the whole rationale. So when the original law came in, the idea was that if a company gives financial support to a company, to a union, that may unduly influence the union, right? And that was the rationale. And so in fact, it was an unfair labor practice to provide financial support. But then if I understand correctly, the unions pushed back on that and said, hey, if we are bargaining in good faith and able to get certain concessions from the company to give us financial support, that's not, we're not being unduly influenced. Isn't that kind of what led to this change?
Right. Actually, in reality, most of the financial support provided by the company written in the CBA was actually acquired by union as a result of very serious CBA negotiation. In the past, there's a lot of strike, unfortunately, in Korea, and employers have very limited remedy against the strike because employers are not prohibited from doing any strike replacements, and all those type of unfair labor practice was also punishable. So in reality in Korea, all of this financial support was actually gained by the labor union and really does not have to be with the autonomous operation of the labor union. And that's where this constitutional court decision is coming from.
Okay, thanks. And just to go to the second bullet point, that dismissed employees can maintain union membership. I think our clients that I've spoken to that are overseas, they find this so strange. Like, okay, I've dismissed someone, but they're still a union member. So what's the rationale behind this?
Right. So I also getting the same question from my client as well. But the key idea is from the ILO convention, which provides that every employer or worker, self-employed person, they all have a right for association, meaning right to unionize. And this ILO convention is mostly supported by European company, where the industry union is more prevalent. But in Korea, we're thinking of mostly the company-based labor union. So that's the differences is coming from. But based on this new ILO, I think the court will really try to expand the membership of the labor union, including those employees who are dismissed from the company.
Okay, please continue.
Okay, so but the law also tried to hit some balance between the employer's right and the union's right. So, for example, non-employee member of the labor union, they cannot be elected as a union officer, and they are also excluded when counting the number of the labor unions in terms of the single bargaining process and the strike vote, etc. And also,
they could be a member of the bargaining team, right? The CBA collective bargaining team. So you could have non-employee members on the team that's you're facing across the table in collective bargaining.
Right, exactly.
So they could still have some significant influence on things.
Of course. And also the law provides that non-employee members can also have a right to enter into the company premises for union activities, but with a certain limitation, meaning to the extent that it does not interfere with efficient operation of the company. But as you can imagine, what is efficient operation? That's very broad concept. So we expect a lot of a dispute will happen in that issue as well. And lastly, the term of the CBA has been extended from 2 years to 3 years. So we hope some stabilization between the labor management relationship in that perspective, hopefully.
And that extension in theory applies to wage agreements too, right? I know the common practices have a wage agreement every year, but in theory, you could push to extend the term of the wage agreement out to 3 years.
Right.
Obviously, the union probably wouldn't want to agree to that, but it's in principle possible.
Right. So there was actually discussion during this legislation process that the wage agreement term should be at least 2 years, but I think that idea was dropped.
Okay.
So what should we expect? The first, as we have mentioned, we expect the expansion of union membership, and definitely more independent contractors will be union eligible. So for example, very special type of workers like for example, deliver of some food delivery company, which traditionally has not been recognized union eligibility based on the previous court decision. But now those riders food delivery company, they made the union and actually started to negotiate with the company. And actually one of the rider union, they executed the CBA with the 배달의 민족, the famous food delivery company. So this is really happening. So if your company has a relationship with any type of independent contractors, then there's a good possibility that those contractors will be union eligible in some way or other. And the other issue is, as we briefly mentioned, the company should now allow the non-employee members of the union to get into the company premise. So the company should come up with certain reasonable policy to decide what extent they will allow this for this non-employee union members. And lastly, actually, this is very interesting point, at least from my perspective, is there's still a contradiction between the ILO convention and the Labor Union Act. So for example, the ILO convention is saying that there should not be any limitation in terms of subject of negotiation between the labor union and the employer. And also it says there should be full autonomy should be provided to the operation of the labor union, which should be decided by the labor union itself. So from that perspective, the current Union Act or the coming Union Act, which prohibits the payment in excess of paid time off system, saying that any agreement in excess of current paid time off system, that is null and void. So that could be actually in violation of the ILO convention. And also the court's cases where it said that the object of strike should be limited to the working terms and conditions only. So for example, strike for acquiring against the layoff was illegal based on the previous Supreme Court cases, but the ILO convention says not. So once this ILO convention becomes a law starting next year, so there should be a lot of a contradiction between the current, either the law or the previous court decision. So we will see a lot of issues coming from.
If I can stop you there, I think that's a very important point because many of our clients are either looking to do like a big restructuring project, or maybe there's a big M&A thing coming up. And as a strategic point, we often look to see, can we do this after the CBA, the collective bargaining agreement has been agreed, because that extinguishes the union strike right, because the strike right only comes along with bargaining about working terms and conditions. You know, an M&A project or a restructuring project is not working terms and conditions. So we could, in effect, extinguish the union strike right when we're doing these big changes, which is helpful to the company, gives some stability. But what you're saying now is with this ILO convention, that strategic advantage that we could get actually may go out the window.
Yes and no. So it is true that, I mean, first of all, I would like to note that the court has been changed its position yet. So, and it's difficult to tell that whether court will change its previous position based on this new ILO. So there's a possibility that court may change its position, but however, even in that case, the union should go on a mediation process to acquire the right to strike. And once the CBA is concluded, then they no longer have a right to go on strike because they have a peace obligation to comply with whatever CBA was executed. So that kind of, our advice should remain the same. But yes, definitely the labor union will bring more issue, especially if they think that they're facing this huge restructuring or layoff.
Speaking of the CBA, we actually got a question about the length of the CBA. And does the new change to the law about the 3-year term for CBA apply to current CBAs?
No, I don't think so. The current CBA will expire, but the new CBA, which will be executed after this new law, it will have a terms of up to 3 years.
Right, so it's not mandatory.
Has to be negotiated.
Yeah, it's still negotiated. It could be 2 years or 3 years, but up to 3 years now.
Right.
Okay, anything else, Hyun-jae? Or
no, that's for all.
Okay.
So lastly, I just had a interesting discussion with some of the judges from the Supreme Court recently. So the judges are also aware of this issue, discrepancy between the positions of the ILO convention and the court's previous position. So actually they said they are really, studying this issue hard and try to come up with some sort of idea before the ILO convention becomes a law next year.
Okay, thank you very much. we just wanted to finish up with just a few recent updates that maybe you're all aware of, but just to make sure. So the 52-hour work week, which is already applicable to many companies based on your size, will now become applicable to all companies with 5 or more employees from July 1st, 2021. And just as a reminder, this means that 52 hours is the statutory limit. Employees should not work more than 52 hours. Otherwise, there can be both criminal and civil liability. This does not apply to managerial level employees, so you don't have to worry about that for them. But yeah, this is an important thing. And there was a 1-year grace period for the larger companies to whom this law was already applicable, but this is now finished. And so it's to be seen how actively the labor authorities will enforce this in this coming year. We've already mentioned the requirement to get the employee representative's consent for substitution of public holidays. This will become effective already now for companies but with 30 or more employees. There's an introduction of reduced working hours for family care as of this year. Previously, reduced working hours was only available for child care. And another change is that the child care leave can now be split into 3 periods. Previously, it was 2. So we're that concludes our presentation. We do have a few more minutes and we welcome any questions. So for those of you that need to drop off, we thank you for your time. Just as a reminder that there is another HR committee meeting on March 30th, which will be hosted by Kelly Services. So we hope that you'll join us for that. And otherwise, please feel free to drop off. Otherwise, we'll stick around for a few minutes to take any questions.